And Frank.
Good afternoon, everyone. Welcome to our Medicaid Monday. Very happy to be here with you today. This is our second in the series, and today we are going to be focusing on nursing home Medicaid. So we're going to talk about the techniques that we have available to us to help get into the nursing home, get Medicaid in place, what it takes to apply, how do you navigate that Medicaid system, and is it possible to save some assets in the process of Medicaid application? So our last program we did was back in March, and that was Community Medicaid. So you can access that on our website. You see the site there, pierrolaw.com. Go to events, and you can log into the prior sessions, and this one will be up there as well. So if you want to go back and review it, or if you have somebody that wasn't able to join us today. So on our first program, again, available at pierrolaw.com events, we talked about home health care, assisted living, the ALT program, which is a limited edition of assisted living coverage under Medicaid, but then managed long-term care and the issues that we're having today in the MLTC world, consumer-directed assistance program, the adult daycare program, and all the things that are available through Community Medicaid, which again has no look-back period. So today, we're going to focus on chronic care, which has a 5-year look-back period and very, very strict eligibility rules. But nonetheless, it is never too late to plan. So with that, what does it cost? What are the nursing home rates in our area? Genworth does a study each year, and they collect up the information. So right now, for a semi-private room, you're looking at about $12,500 per month. Private room, $13,166. And Frank, these are average rates. These are not the highest. These are not the best facilities. And sometimes the facilities do differ based upon the cost that you're paying. But nonetheless, when you run the numbers, and we won't take our calculators out, we've done that for you.
Not yet.
It's $150,000 per year for a semi-private room on average in the Capital District of New York. We practice in Long Island. We practice in Manhattan. Downstate, that average is probably $180,000. So it's a disparate system and an expensive system. And what does it take for Medicaid to begin to pay your bills? Because remember, Medicare doesn't touch this. If you have Medicare, Medicare supplement does not pay for a long-term stay in a nursing home. This is not Medicare planning. This is Medicaid planning. And so when you're looking at that, Frank, what do they allow you to keep and still get Medicaid coverage?
Sure. So just like last time, we have to talk about income and assets separately because the Medicaid land, as I like to dwell, that's always two different things we have to talk about. So fortunately or unfortunately, the asset and income information for nursing homes is a little simpler than home care because of the look back and things like that. So for income purposes, if you're in the nursing home, you're a single person, you're applying for Medicaid, your income number, it's really simple. You get to keep $50 a month. You have other deductions like your health insurance premiums, your dental premium, your vision premium, something like that. But it's basically $50 plus your premiums. That's it. Your rest of your income goes to the nursing home. So that's your IRAs, your pensions, any interest, dividends, Social Security, all that, all goes to the nursing home except $50. Pretty cut and dry, pretty simple. Individual for asset or resources on the page, same as last time, $15,450 for one individual. We don't double it if we're talking about two people applying separately. And we also have that bottom number, the community spouse resource allowance, which is basically $75,000 up to $126,000 for the community spouse. Now, one number I do want to direct your attention to is something called the MMMNA or the MIMNA, which is $3,160, 50 cents per month. What that is if you have a loved one, like your spouse who's in the nursing home, you're well, your spouse is in the nursing home, that's the amount of income the community spouse can keep. Just so for argument's sake, we usually say $3,100 or $3,000 just to give a round number. But that's generally what the spouse at home, that's what they can keep between their own income. And if they don't make enough, they also can get a portion of their spouse's income. We'll talk a little bit about that later.
So we want to focus on a single individual right now. We'll get back to those married couple numbers, but some assets, Frank, don't count towards that $15,000 450. So why don't you walk our listeners through that?
Sure, and this is important. So this is, if there's a few takeaways that you take away from today's program, hopefully these are a few that maybe you didn't know about. So your home is an exempt resource as long as you, meaning the Medicaid applicant, or your spouse lives there, up to an equity limit of about $878,000. There are also other individuals that can live in the house, so it gets special treatment and it's exempt, just like a disabled child, or if there's a caregiver child, there's certain times when that child could be gifted equity interest in the house. There's a sibling also that could have a certain equity interest to preserve the house. We don't want to dive into that too much today, but just know the house, there generally is a way to save it, especially if there's a spouse in the community. You can have an automobile regardless of value. So my joke always is you could have a Porsche sitting in the parking lot of the nursing home. If that's your one car and you're one person, you can have that car. It doesn't matter how much it's worth. They also allow you to prepay your burial and your funeral arrangements. The only caveat that comes with that is that should be an irrevocable arrangement rather than a revocable arrangement. If you have a revocable, all you have to do is change it. There's also other things that are exempt that we talk to clients about all the time. So if you have a business that's operating, so an operating income producing business or property, that's exempt. The income that you receive from it is not, but the actual asset itself is. A very small amount of life insurance is exempt, but it has to have a face value of less than $1,500. Most policies we see have face values that are much higher than that. So most of the time your life insurance will not be protected, but that's why we always want to see the numbers associated with any policy that we're talking to people about. The other last big takeaway is your IRA or your 401k, your retirement account. As long as it's in periodic payment status, again, the asset is exempt, the income from it is not. So typically when we're talking with clients and they have retirement assets, they want to protect them. Generally, there is always a way to save those, just not the income from those.
So, Frank, when we look at the eligibility rules, we have to look at what's exempt, what's not exempt. And we try to maximize the value of your exempt assets. Looking at your retirement accounts, 401ks, IRAs, that by far, other than the home, is the largest asset that can be excluded from Medicaid counting. So we work real hard with our clients to make sure that either they're in what's called periodic payment status or we put them in periodic payment status.
Correct.
But if you have a retirement account, you can work to, even if you're not 70 and a half yet, you can work to exempt that by beginning early distributions from the IRA account. And that is a major exception. Unfortunately, Frank, in this world, we see a lot of misinformation and disinformation out there. So you really need to know the facts. These are the rules. We've been doing Medicaid for over 30 years. We've done a lot of litigation. We've been in the courts many, many times at fair hearings litigating Medicaid issues. Right now, we don't do a lot of litigation because the rules are pretty tried and true, but you need to know the facts. And these are the facts of Medicaid eligibility. So take these down, and these are the things that we can talk to you about, or you can research on your own. But these are the exemptions with regard to Medicaid eligibility. And most of you have probably heard something about a 5-year look back. Mm-hmm. Almost every client has heard something. Some think it's 8 years, 7 years, 10 years, 3 years. But right now, for Medicaid eligibility purposes, the look back period is 5 years. And Frank, explain that to our listeners. How does that impact your Medicaid application?
Sure. So the look back really is just, it's when the county is going to do an audit of your past financial history. So the way that we work with our clients to accomplish getting through the look back and dealing with any problems it has is we ask you for 5 years of records or statements for every financial account that you have. So that's your bank account, your retirement account, your brokerage account, your life insurance, your taxes, all of those things. And we go through them. And all we're looking for really are transfers or gifts, things that you gave away from yourself to someone other than yourself or your spouse. Then we try to, put a comprehensive package together for when we submit it to the local county office, showing this is what accounts existed. These are the statements for each account. These are the transfers we're worried about. And if there's any explanations or any ways of getting around a transfer in the past, we work with our clients to accomplish that, to try to get that penalty as low as we can. Hopefully it's nothing, but sometimes things have been done in the past that can't be undone.
So we're going to talk about the penalty period, but can you just give our listeners an introduction to the difference between the look back period, which most of them know, mm-hmm. and a penalty period, which is once you've done that thorough audit.
Sure.
And we can't emphasize enough how important it is not to miss anything.
Sure. So the look back is just the previous 5 years from when we're basically submitting an application. So if we submitted an application this month, we'd really want to go from April 1st of 2019 back to April 1st of 2014. So the past 5 years of financial history. In that audit, we're going to start to tally up all the transfers or gifts in that period that we find. Once we have a sum of all those gifts, we add them all together. We get an aggregate total. And then we divide it by the divisor for the penalty period, which is set by New York State. Thank you, Lou. They're in front of you right now. So the one that we see the most in our office, just because it covers the Albany area, is $11,280. So all you do is you take the total number of gifts that you gave away and the sum of all those gifts divided by 11,280. The number that you get when you do that calculation is going to determine how many months of ineligibility that person is going to have before Medicaid is going to start paying for them.
And you saw the number that we had for the average cost of nursing home care. This is not that. What the state gives us is a number that's premised off of the actual Medicaid reimbursement rate. And the private pay rate and the Medicaid rate are vastly different. Nursing homes don't get reimbursed from Medicaid amount that they charge you privately. So what New York has done, because they don't want to go around and have to do a poll like Genworth did of every private pay nursing home rate, they already know what the Medicaid reimbursement rates are because they're paying it. So they have taken that and multiplied it by 120%. And that's the average number that you see here for upstate or northeastern New York. We practice again in Long Island, Nassau, and Suffolk counties, 13,407. In the New York City area, 12,419. So all the counties are here. Look at where you are. And that number is an important number. And we're going to go through a case study, an example, showing you how that average regional rate plays in. And it does change every year. And even though you have that rear view mirror and you're looking back 5 years, it's the rate that applies in the year of application that applies to your transfers. And that's what we're going to use to calculate that penalty period. So these are some common examples, Frank, of things that trigger a penalty.
Sure. And obviously this can vary a little bit, but typically if people have given money away, it's for things like graduations or birthdays, things like Christmas. Sometimes if a person's getting a little older, they don't need a car anymore because maybe it's not so safe for them to drive anymore. So they might just give their car away to a family member, or they may sell it for a very discounted rate. So I think that's one of the misconceptions that people have. Just because you sold it for, hypothetically for $5 or $1 if it's real property, just because technically you said that you sold it and a very small amount of money changed hands. In the eyes of Medicaid, that's not a true sale. It's not an at-length transaction. So they're going to penalize you for that if they know that's what's happened.
So if I had $1 for every client that came in and said, well, I want to sell my house to my children for $1, does that get it out of my estate for Medicaid purposes? And the answer, for that $1 it does, but for the other balance, no, it's a gift. So if you have a $200,000 house and you sell it for $1, you've got a $1 sale and a $199,999 gift. And that's what's going to plug into the calculation that we're going to take a look at in the next slide for the calculation of that penalty period. But Frank, not all transfers are penalized. What are some exceptions?
Sure. So one of the ones that we use all the time is a transfer between spouses. So typically we have one spouse that may need the nursing home because of medical reasons. One spouse probably is okay to live at home, if not forever, at least for a while. So the Medicaid needy spouse can transfer all of their assets free of penalty to their spouse to get the plan going. That way they look like they have less than $15,450 by the time we're going to apply.
So hold that rule in mind when we go back to the spousal eligibility rules, the MMMNA and CSRA. Hold in your mind the fact that you can transfer assets spouse to spouse without impacting the Medicaid applicant's penalty. So that's one rule to keep in mind. The other is one that a lot of people miss.
And that's the disabled child rule. So we try to make it a point of emphasis in our consultations to ask people, do you have a disabled child? Not because we wish that your child was disabled. It just presents a very unique and very good planning opportunity for us. So if you have a disabled child, meaning that they're receiving Social Security disability payments, or they've been determined to be disabled by Social Security, they can be gifted assets free of penalty.
We have actually done it with veterans who are disabled under the VA law. They have 100% VA disability. We've been able to get them qualified as a disabled child. And a parent can transfer 100% of their assets to that child with a disability, and there is no waiting period for Medicaid. So even though there's a 5-year look back, there is a zero penalty for those transfers to a disabled child. So something that you have to ask the question every time you do this planning. And we have a questionnaire that we use. You may say, well, how do you get all this information together? We've assembled a questionnaire that you can download off our website. It's on the resources page at pierrolaw.com that has these questions embedded in it. So if you go through that and line by line answer the questions, these rules will kick up. And we talked about the home earlier. There are some special circumstances under which the home can be transferred to, for example, a child who is a caregiver in the home for 2 years prior to eligibility. If they've provided services, caregiving to the parent can transfer the home to them free of any penalty period. Also, this is one that's we've only used a few times in my 35-year career, and that's a sibling, a brother or sister who has lived in the home with their other brother or sister and who has paid into the house in the way of expenses, helped to make mortgage payments, helped to make payments for heat, utilities, maintain the house. They establish what's called an equity interest in the house, and if that has lasted more than 1 year prior to Medicaid application, that sibling can receive the house free of any Medicaid penalty. But for everything else, Frank, there is a penalty. So how does that work?
So again, we aggregate we sum up the total number of transfers that we found in the past 5 years when we audit everything. So the slide in front of you says, for example, if we found $112,800 worth of transfers that we have to deal with, we take that number, we divide it by our penalty divisor from a few slides ago, and that would leave us in this example with a 10-month period of ineligibility because of all those transfers that were made. And that penalty, here's another misconception, is that penalty doesn't start to run at the time of the transfer like it used to. Mm-hmm. Now the penalty only begins to run when the person that's applying for Medicaid is actually in a nursing home, is otherwise eligible, meaning that they now have less than $15,450 of assets, and an actual Medicaid application has been submitted on their behalf to the local county Department of Social Service.
Now, that's a lot to remember. But that if you're in northeastern New York, that $11,280 number is a critical number because that's going to plug into our calculus. And we can't run the penalty at the time of the transfer. You don't have the penalty period even begin to run until the person's in the nursing home, has already gotten down to the $15,450, and then actually files the Medicaid application. It's the filing of the application that triggers that penalty period. So who pays during that penalty is something that our clients often ask. If I do this transfer and I have to get Medicaid within the 5-year look-back period, what happens? And this was a rule that was added by Congress back in 2005 as part of the Deficit Recovery Act of 2005. And it really presents a trap for the unwary. Because if you make those gifts within 5 years of a nursing home, and you could be paying a child's college education, grandchild's college education, giving to your church, aggregate all of those transfers during the 5-year period, and then at the time of application, you apply the penalty period. So for 10 months, I'm going to be ineligible based upon all of those gifts and transfers that I made over the last 5 years. If I only have $15,000 left, who will pay? Is the game over at that point? And the answer is there are some remedial measures that you can take, something called a gift back, that some counties will allow where you can actually give money back to the person who gave it away in the first place, provided you can still find the funds. And that's a problem in many cases. But if you can give it back, you can sometimes vitiate or erase the penalty period, and that will get you back to a square where you can get Medicaid in place and still have enough money by those returned gifts to private pay. But there's a better way to do this. And it used to be the rule of halves was simply gifting about half of your assets and holding about half your assets that you could use to private pay the nursing home. So to take our example from the prior slide, if we're looking at total assets of twice that 112.8, so about $224,000, if I have $224,000 and I gift 112, I have a 10-month penalty. But if I kept 112 under the old rules, I could use that to pay the nursing home while I wait out that penalty. But these DRA changes gave rise to a series of cases that were litigated, two of which we did here in our office. And we carved out territory where you can kind of re-engineer the rule of halves. And this is part of what we do for clients in helping to protect and preserve assets. Even clients who have been in the nursing home for a year and have private paid $150,000, if they have money left, we can help save that even at that point in time. So the promissory note is something that has been utilized and developed to re-engineer this rule of halves transfer. So the note has been ruled through those court cases, through fair hearings and other litigation, not to be an asset and not to be a transfer. So in effect, instead of gifting half and keeping half to pay the nursing home, we gift half and we loan the other half out under a promissory note to get back payments sufficient to private pay the nursing home. So let's take a look at an example. I don't think you can really follow this logic without putting some numbers to it. Bob has $24.50 a month of income, $4,000 of non-exempt assets, and he has a nursing home that's costing $13,680 per month. Part of the planning for Bob is a spend down. What are the things Bob can spend money on that do not count as a transfer? One of them is prepaid funeral expenses, funeral and burial expenses. So we go out and we prepay our funeral and burial, an irrevocable fund at that point. You can buy Bob all the things he needs for his room. You can buy him clothes to last literally the rest of his life. Buy him the new big screen TV to put in his room. Spend it down on all of those things. And one of the other items that is a spend down item is a payment of legal fees to do the planning and to do the asset protection and Medicaid application. So that is also a legitimate spend down item. One little caveat there, make sure that all of the spend down items have cleared the account by the first of the month. Medicaid works on a snapshot basis. First of the month, if the money's in the account, even if you've written a check for it, it still belongs to the Medicaid applicant. So we've done planning in as little as 5 hours, and Frank will attest to that, where we sent someone to the bank, get a cashier's check, get it drawn on the account, which debits the account immediately because the county is going to look at all of the balances in place on the first of the month. So make sure you get all of this done prior to the first of the month. And then what we have left here is the non-exempt assets. And we're going to make a gift of $180,480, and we're going to do a loan of $180,480. When is Bob eligible for Medicaid, and how much has he saved? So let's run the numbers. We start out with the nursing home cost of $13,680. Bob has income of $2,450. Frank told you that he gets to keep $50 a month of that. So $2,400 is going to go toward the cost of care, leaving us, oh, look at that, what a coincidence, $11,280 a month that he needs to private pay the nursing home. And remember, that's also our divisor for the penalty period. So Bob has non-exempt assets of $410,000. He's going to spend down that $33,590 on a variety of expenses. He's allowed to keep $15,450, leaving at-risk capital of $360,960. So our gift of $184.80 is half of that total of non-exempt assets. You divide that by the $11,280, and here's our penalty period, Frank. It's 16 months. We then look at a loan of $180,480, 16 equal payments over the next 16 months of $11,280, which is the number needed to private pay the nursing home. So we apply in May with a May 1 pickup date. We have a 16-month ineligibility period going to August 31 of 2020. We have a promissory note that's going to pay over the next 16 months to private pay the nursing home, so we have no outstanding obligation to the nursing home over that same 16-month period. And on September 1 of 2020, Bob is eligible for Medicaid. He now has, Frank, in his trust, $180,480. He's kept his allowance of $15,450, has the prepaid funeral contract of $12,000, and personal property purchases of $7,900. So even with Bob going into the nursing home, he was able to save for his family $215,840. And September 1 of 2020, Medicaid pays.
Simple.
So for married couples, Frank, there are some other rules that we need to know.
So people always come in and they say, well, if Medicaid's so costly, or if private pay is so costly, and if there's one spouse at home and we have to impoverish the Medicaid applicant, what's going to happen to mom or dad, whoever the well spouse is? Because we have to be poor, they're not medically needy enough for the nursing home in a lot of instances. So what's going to happen to them?
And a lot of times those spouses are younger and they have long life expectancies that they need to live on. So getting down to the impoverishment levels is very difficult.
So there's two numbers that we talk about. One is the MMMNA, the MIMNA, as we talked about before, which deals with your income, or your CSRA, or your Community Spouse Resource Allowance, that deals with your assets. We've mentioned those numbers already, but now we can go into a little more detail about that. So your MMMNA is the amount of income that the community spouse is allowed to have. So that number is $3,160.50 per month. The best way to think of this is that's what the community spouse can have if they make less than that. So let's just say, off the top of my head, the community spouse makes about $2,000 of her own income. That means $1,160.50 can be diverted over from her spouse in the nursing home to her to bring her up to that $3,160.50 number. It's a number that exists to make sure that the person living in the community isn't completely impoverished herself, that she can continue to lead her life as she needs to, pay for groceries, taxes, utilities, those types of things that you need when you're in the community.
And this was brought in by Congress in 1988 as part of the Medicare Catastrophic Coverage Act. It does not apply to home care benefits. So again, we have the prior video talking about community benefits and how the rules work there. The MMMNA protection is not part of true community-based Medicaid. So the resources, Frank?
So that's your CSRA. So the way that I like to explain it to clients is just think about $75,000. That's the best way to know what you're guaranteed to be able to have as the community spouse. You can have about $75,000 in assets, not counting those things that don't count that we talked about earlier. However, you can get more than that, but that gets very dicey with the calculation. So you get basically between $75,000 and $126,420, depending on what assets are and how they're titled.
Now I have a quick question.
Sure.
Can the Medicaid applicant also keep the individual resource allowance of $15,540 in addition to this?
They can. So the bottom number with the $75,000 for the community spouse and the $15,000 roughly for the Medicaid spouse puts you right about $90,000 total off the table immediately.
So sometimes that's not enough, and spouses planning to live a good long time on their assets don't want to turn those assets over. And there are a lot of circumstances where you have spousal liability where the spouses have even been separated. If they're not yet divorced, you have issues with regard to that. So there's a technique developed to help protect those spouses. And tell us a little bit about that.
So it's what's on the slide in front of all the good folks listening at home right now. It's spousal refusal. So it's basically the well spouse is refusing to contribute their assets and their income towards the cost of care for their spouse. By doing that, it takes the income and the assets of the well spouse off the table to determine whether the Medicaid applicant is actually ready and financially eligible for Medicaid in the nursing home.
The game.
It's not, unfortunately.
So when you apply, when you actually file the Medicaid application and the spouse signs, whoever the representative signs, or the Medicaid applicant themselves signs, there is an assignment of rights from the Medicaid applicant to the county. And the county inures to the benefit of all of the rights of that Medicaid applicant, including what is in New York, a spousal right of support. So Medicaid can enforce that right. And depending upon the county, some are more aggressive than others. We see this all over the state. How many counties have you applied for Medicaid in, Frank?
Probably at least 30, 35.
And New York has 57, so we're getting there. But we've applied in 30 counties, and the treatment of all of this is different in each county. So we have gotten to know the people there and know what the county's predilections are, which is important when you're starting to counsel people on things like this, which could result in a claim for spousal support. We haven't seen a lot of them lately.
No, thankfully.
But it's a possibility, so you have to be aware of that. And part of that plan that we just talked about was creating a trust to shelter assets. And that is the subject of our next webinar, which is going to be coming up. We'll give you the date, June 10th, and that's going to be our third installment. And again, you can go back and watch the first installment on community-based Medicaid. You can watch the installment on Medicaid asset protection. You can watch it on managed long-term care. So is this number 4 that's coming up?
June, there's actually one in between.
Okay. So this one is coming up. The managed long-term care is coming up in May. And so this one is going to be on trust planning. How do you structure that trust? What are the characteristics of the trust? Stay tuned for that on June 10th. And here is how you can go back and watch the prior episode, which is from March, and that was on community Medicaid. Managed long-term care, May 13th, and Medicaid Asset Protection Trust will be coming up on June 10th. It's a lot to listen to. It's a lot to go over. We went pretty quickly in our 30 minutes, but remember, you can always log back into the website. This will be put up within the week so that you can view it on our website and go through all of the rules. And we're going to go now to, you can click here if you want to get a consultation. Our marketing department is here guiding me on that. So you can get a free consultation if you click there, and you can always email us if you have questions at info@pierrolaw.com. We welcome your questions. We love educated clients because they come in and they know what they're doing and they know the plan. We want you to understand it before you do it. So we hope these webinars are helpful to you in that regard. With that, I think we conclude for today. Thank you all for your time. Thanks for joining us on today's webinar.